Ms. Curtis, can you hear?
Yes, I can hear you.
Ms.
Can you
Curtis,
hear
you
me?
got to turn your camera on. I don't speak to a black square with a name. Ms. Curtis, say something, see if we can hear you.
Hello, hello, hello. Testing 1, 2, 3.
Can't hear you. You must not be connected. Yeah, can't hear you.
Hello, hello,
Yeah, she
hello.
can't. We're not going to be able to hear her. So for the record, Ms. Sanders, this is an email from Sade Curtis, SADE, yahoo.com to Mr. Norman. It was sent on 1/31/2025. Looks like it was forwarded to him. To whom it may concern, this document affidavit is to verify the truth of the police report at hand. My name is Sade Curtis. Upon the release of Deshaun Atmore Meta, there were no issues. The contact described in the police report is not physical, violent, nor was I or my child in harm's way. The argument report is an argument overheard by a neighbor who then called the police for a noise complaint. Police were not called due to acts of violence. Mr. Atmore did not pull a knife on me, nor was there any physical exchange. The police report was filed due to Mr. Atmore opening a CPS case. Once the CPS case started, Sade Curtis was instructed by the caseworker that if I wanted to remain in primary custody of the parent, there needed to be a police report on file in regard to the incident or complaint where Mr. Atmore be deemed unfit. Police report was filed after once the caseworker told me it was needed for my case to be dismissed. Mr. Atmore and I have chosen to co-parent for the betterment of our child. Any time spent away is detrimental to the upbringing of our daughter. He's loved by his daughter and family. Best, Sade Curtis. So I'll just tell you this, sir. There's a couple things I found wrong. One, that she went a couple days later so that you would be denied custody of this poor child who in the middle is the victim. And it's bothersome that DFACS in New York or whomever it was told her, go make a police report so that we can do this. So either one, and didn't say anything about a neighbor calling. She went because obviously there's no police report of a domestic disturbance with a phone call, right? Is there, Madam probation officer, you know about? All right. So she goes down, does this, probably so she can manipulate the system and have him with the child. But one, I'm looking at your conditions of probation. It's right there in bold for the violent contact with the victim, and it tells you that you can't travel. And I'm pretty familiar with these people at probation, and they go over all the other special conditions. So you knew you couldn't travel. And it honestly would have been as simple as you saying, hey, it's around the holidays, or it's my daughter's birthday, or what have you. Can I travel? And they would say, yeah, most likely. So I don't know. I mean, like I said, she can't speak, and it's good or whatever that you guys worked it out. But guess what? If that's what she's going to do, and she's going to report you and have you arrested just to do that, she's right there using the manipulation you by that child. So I'm going to go ahead and follow the recommendation of the state. And he has been in, I mean, here's the thing I'll tell you, Ms. Curtis.
How is it you can't hear me? Can you hear me, Your Honor?
Here's the thing. I'm going to swear you in. I'm going to ask you these questions, and lying to this court could get you in a whole bunch of trouble.
Okay.
Not just here, but up in New York with the child services or DFACS up there. So they'll find out that you lied, and then they may take you, I don't know, but it's going to get you in more trouble than you really want. All right. So I'm going to tell you, you got the right to remain silent because anything you say would be used against you and can be in a court of law. All right. So give me a thumbs up or a thumbs down if you still want to testify. You got to turn your camera on. Still got to turn that camera on. Still got to turn the camera on. Ms. Curtis, if you don't turn the camera on, I will take that as you do not want to testify. So, yeah, she obviously, Ms. Curtis, turn your camera on. All right, she doesn't want to testify. So give him credit for, says 1 month and 9 days, but however long he's been in custody in Fulton County. I mean, she was sitting there on the video shaking her head, and then she just turned her camera off. I don't know if Mr. Norman wants you to speak.
You would like to address the court.
All right, so you discussed it with your lawyer. I know it may be against his advice, but you're choosing to speak. on your behalf and ignoring Mr. Norman's advice? All right, go ahead.
Hello, Your Honor, are you
What
able
did
to
you
hear?
want to say? I still can't hear.
Hello? Hello,
I
hello?
can see she's saying hello, but guess what? We don't have audio because that podium's not working. So say what you want to say.
My phone just died as I was being
Okay.
sworn, so I don't know where I pick up from there. Hello? Can you hear me, Judge? Can you hear me?
But like I said, obviously, some people call it violence if you're screaming at one another. So let's just say they were screaming at one another and a neighbor called, and instead the other happened. I think all that's violence. But I'll tell you, Mr. Norman.
This is the first revocation, like a month after he was on probation. That's important to consider something less than a full revocation. Given that he appeared, he's employed. There wasn't a violent contact. He's admitted his mistake and he's ready to correct it.
So his charges were ag assault, criminal damage to property, battery against the female who's pregnant, obstructing a 911 call. Those were the original ones. So she lives up in New York. So how are you going to see the baby? Because you can't travel.
Because there's a CPS case now.
Yeah.
He's only gonna be able to see the child and
One at a time for the
he's only gonna be able to see the child and CPS allows whatever they do that. He
And
has no reason to see her.
all right, so you got 2 years, 11 months, and 5 days as of 4, so it's a little less than that now.
He did be 586 days in the original.
And you still got to do your family violence intervention program and your anger management that you haven't done. So we'll revoke, I'll revoke 1 year right now, day for day.
But it's 40 days.
Yeah. Credit for his time in Fulton County. Ms. Curtis, I know you can hear me, but stop lying on people. All right, next.
Yep. Okay. Go.
Will you hand me my screen box?
Now go. This is 24 SC 003-048. State
Your Honor.
of Georgia versus Kashawn Patterson. So, Mr. Norman, am I correct? There's 3 motions pending?
There are 3 motions pending. I believe we have stipulations on 2 and an agreement on the 3rd. Just for the record, I filed a motion to sever the offenses. Mr. Patterson is charged for incidents on 2 different dates, a January date and an April date. And I believe my understanding, I don't want to speak for the state, but we've agreed to stipulate that we can sever the January offense from the April offense.
Yes, good morning, Your Honor. The state does not oppose the motion for severance. And because of that, Your Honor, when these cases, if these cases are severance, there is the second motion is to bifurcate the possession of firearm by convicted felon charge. By law, we will also agree to bifurcate that charge.
Okay.
So we can file orders regarding those cases. And the 3rd motion I filed was regarding if Mr. Patterson chooses to testify, his record being not being able to bring up his prior criminal history.
404B, yeah.
Yeah, and so I would, in talking to the state, what I'd like to do is wait until the beginning of my case, and then we can deal with that motion if he is in fact choosing to testify.
All right.
And then I believe Mr. Patterson filed a motion on his own. I am not joining in that motion. And I guess he can address the court regarding that if you'd like to hear from him regarding the motion that he filed.
I got it. Yeah, okay. All right, come on up, sir. Are you familiar with the state familiar with this one?
I'm sorry, Judge.
Are you familiar with this one?
I am familiar
Okay,
with it.
all right. So this is a motion to remove counsel.
Yes, ma'am.
alleged misconduct and ineffective assistance of counsel. All right, Mr. Patterson.
Yes, ma'am. I'm having, me and my lawyer having irreconcilable differences, and I had stated a claim for which relief could be granted. The last judge, well, Judge Schwartz said I couldn't get rid of him, so the next action I can undertake now is to write the Bar Association to force him to withdraw. He's not helping me in the manner of which he should be. This case never went this far, you know what I'm saying? He never even put in for evidentiary hearing. They have nothing, all I have is statements and accusations this far. I have nothing else. I even have the 911 call or the body cam footage. It's the actual nature of the call. You know what I'm saying? And this is some of the things that I've been feeling like they've been obstructing evidence. The same thing with the phone calls and all that stuff. I asked him to let me listen to the phone calls. He brought me a packet where the victim is saying, I never said that, you know, she's denying this. District attorney know these things. They keep, nothing ain't going. I just don't want this lawyer no more because he's not doing what he's supposed to do. So now it's becoming an appellate issue. I don't need him on my case.
So
I ask that you please grant relief by removing him.
If I may, Your Honor.
Sure.
Just in response, the motion that Mr. Patterson filed is most related to the attorney that handled the pre-indictment. He did make an allegation that I failed to file his speedy trial motion. That's obviously been filed because he's got a speedy trial date.
right.
As far as his discovery goes, that was provided to him. He did request an audio recording of the preliminary examination. I contacted the court reporter who said that did not exist. It is destroyed once there is a transcript. He did request video from a Vivint camera at the residence. Again, by the time I get the case, that exists only for 14 days. By the time I have the case, that video no longer existed. And I believe the third thing he requested is to listen to his jail calls, which he made. I didn't provide transcripts of a call to him. However, the only thing we can do, because we can't provide a thumb drive to the inmate, is my investigator would have to go sit there for 20 hours for him to listen to the calls that he was on. Aside from that, I have filed motions. I have filed his speedy. I've gone over his discovery. The issues he has relate to factual issues, which are trial issues. However, if he is, if he's not comfortable proceeding with me, I have no problem, withdrawing from the case, but I don't know. I think he would have to hire an attorney at this point.
Hey, ma'am, the calls he's saying that's 20 hours long, that's not true. There was only like 7 calls, and we probably spoke for 3-4 minutes. So if you combine them all, it's probably like about an hour at most. And he couldn't even let me listen to those calls.
But you were on those calls, so.
I am on those calls, and there's certain things I want to point out because I already done filed to the district court on habeas corpus on perjury. They got a lot of things. You can't lie about one thing and tell the truth about another. It does not work that way. So there's a whole lot of stuff in there, like the recording that she had for us, the audio. You know what I'm saying? She said that we in a preliminary hearing, she stated that there was some I asked her about having sex that night, and she said that she couldn't. But when the recording starts, it's talking about something else. She perjured in there.
I did not go forward with any facts regarding the case.
It's all factual. I'm saying I'm here for something that I didn't do.
It could be used against you. So here's the thing. When it's an appointed attorney, you can't really fire him. So, I mean, you can, but then they're not going to appoint you another public defender. You got the money to hire somebody?
No, I ain't got the money to hire nobody. But if he ain't, I'm saying I'm being forced to trial with a lawyer that's not working for me. He's not doing none of the things he's supposed to be doing.
Did you not listen to what he said?
I heard what he said. What he said is not true, ma'am.
Just because you say it's not?
No, because I'm saying everything that I've been asking him to bring to me so we can go across it. He don't even have a defense for trial. That's in 10 days from now. He don't even have a defense for trial. Nothing. And all these charges, the gun just now getting handled. The gun should have been handled a long time ago when he looked at the search warrant and seen that it wasn't specified in the warrant. He should have been took care of that. Why we get to this point 9 months down the road, we just speaking on the gun. Where's the DNA evidence? Did we ever got that back? We just keep moving off of accusations.
They don't have to turn it over to
These
you.
are all factual issues, Your Honor.
Right. These are all, yeah, definitely. They're,
Legal issues.
I'm saying, but he's not doing his job. I'm having irreconcilable differences, ma'am. I stated a claim for which relief could be granted. I'm asking the court to remove this counsel from me, please.
anything from the state.
Nothing from the state, Your Honor, if you find that, if you grant his motion, Your Honor, the state just asks that there is a speedy filed in this case, if it can be, withdrawn, and he move forward pro se, if he wishes.
That's being forced. I have never waived having an attorney. I just said I want this attorney.
Okay, but you can't fire somebody who's appointed to represent, you can't just keep firing them and going through.
I ain't had this the first, no,
But I tell you what,
the first lawyer I had on this case, the other one was for preliminary. She withdrew on her own. I never fired her.
because her, what she does is preliminary hearings.
Exactly. So
Here you
I
go.
never
I tell you
fired
what,
anybody else.
Stan, what I'm gonna do is I'm gonna grant you that divorce since y'all have irreconcilable differences, but I'm not gonna remove him as your lawyer. Everything he said makes exact sense. They only have recordings for so long. And he's doing his job, and the state doesn't have to turn over discovery as of yet, probably. So there's timelines. So you need to, all right. So no, I'm not gonna remove him
Okay,
from.
my last argument is this here. The victim said I didn't stay at the house. I have a vivid security home system that he can use by my social security number, prove that I've lived there.
Okay, listen to me. What you're saying now, they're gonna get a transcript of this and use it in court against you.
Okay.
So when that person gets up there and says something different, no, let Mr. Norman do his job. I promise you, he can do a much better job representing himself, you than you representing yourself.
I never asked to represent myself, ma'am.
That's your only choice. Hire somebody to represent yourself.
I just let the bar association just deal with it. I just made this complaint with them. It's going to be an appellate issue. I'm letting the record reflect that I've spoken to you about it already. I stated the claim for which relief could be granted. You still refuse the motions. I done district court, everything. I keep saying this man is ineffective to me. And I have, under my Sixth Amendment right, I have a right to an effective counsel. And you keep saying, just stay with it. And I already know he's not working in my best interest. He's working more in the district attorney interest than anybody.
Okay, so Mr. Norman's your lawyer, unless he just, he finds some reason he wants to withdraw. He's doing everything he's supposed to do. Sometimes things don't move at the pace you want it to. Okay, next.
Uh-huh.
So who's going to send me the orders?
I can, I'll prepare.
Okay, thank you. And so you'll agree.
No more comments. Get out of the courtroom before you're talking.
Are you kidding me?
Oh my God.
You have got to be kidding me. What? What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're going to start bringing people in person. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.